On.
Good morning, all. It is November 1st, 2021, and we are here meeting with the Joint Legislative Management Committee. And I'm looking around to make sure we have a quorum. Yes, we do. Excellent. So first order of business is to invite our Director of Human Resources, Arlene Donovan, to join us up here. Just as way of explanation for those who may be tuning in, our predecessors, Pro Tem Tim Ash and Speaker of the House Mitzi Johnson, did an incredible amount of work with the previous Joint Legislative Management Committee. We have some of those same members continue on the committee, did a lot of work to hire an HR director for the legislative branch. It had been a long time in coming. There was a need to bring all the different departments within the legislative branch under one umbrella of policy and procedures, and it's a big undertaking. And so here today is Arlene to take us through some work that she's been doing on human resource policies. So Arlene, thank you so much for joining us on this
Good morning.
Monday morning.
Good morning.
And you should all have links to the documents, but there are also hard copies of the documents on the table.
Yeah, good morning, everybody. Thank you for having me this morning. Arlene Donovan, Human Resources Director for the General Assembly. And I wanted to thank you all for taking the time this morning for spending a little time with me to discuss our first set of policies, not our last, but our first set of draft policies for our legislative staff. You may remember when I started back in April, 6 months already. When I started 6 months ago, I had a bit of a roadmap to follow. And one of my priorities was to try to identify policies and draft at least an initial set of policies that I thought would be beneficial for our staff. So that's what I set out to do. So over the next 10 minutes, I'd like to spend a little bit of time explaining to you how we've gotten to this point. I think it will be important for you to hear the work that's been done behind the scenes. And then I can pause there and we can talk about how to proceed. So when I first started, I spent a lot of time meeting with our staff and our department heads. It was important to me, being new, to hear people's thoughts about what we already had in place, what policies we were following, what procedures we were using, what was working well and what wasn't working so well, and where some of the opportunities for improvement might be. So I collected a lot of that information, which was very helpful. It helped me to come up with a list of policies that I would like to focus on over the coming year. And I decided, based on those conversations, that it made the most sense to start focusing on leaves of absence. I don't know if any of you have had any experience with leave of absence policies, but they are traditionally very complicated to understand. They confuse people, they are hard to manage. And so I figured, because we did have some employees at that time who had experienced leaves and still do today, that it would be a best place to start. And that's what I set out to do. So I had to do a lot of research in order to tackle this. And I think that will be the case not only for this set of policies, but for any that are written for our staff going forward. I looked at all kinds of things, like not only what we had in place, but the statutes that are currently in place. I looked at other policies that state employees are abiding by, even though they don't necessarily always apply to us. We have historically, I found, fallen back on those when we needed more guidance or clarity. So took a look at those. I reached out to NCSL as well to see what other state legislatures have in place for HR policies. And again, they're not necessarily applicable to us, but was helpful to use as a benchmark. Also looked at some of the federal laws. Sometimes they don't apply to us as well, but again, helpful to use as a comparator. And with all of that, started drafting policies that would be helpful for our staff and our directors. and policies that can be used consistently and equitably across all of our offices. And that really was the goal for all of us. So in the course of all of this work, I did work very, very closely with Leg Counsel, specifically with Damian Leonard, who devoted a lot of time and energy to this effort as well. Every time I drafted something, he helped put a legal set of eyes on it and edited them. Spent a lot of time doing that. And once we felt as though we had a solid set of policies, I reached out to our department heads. So I met with them individually. We had lengthy conversations about these policies. They had questions for me, and I had questions for them, and we all had questions for Damian. Collected a lot of feedback and incorporated that feedback and rolled those into a new set of drafts. Those sets of drafts were brought again to the director group, to the department head group, but we met this time as a group in a group meeting. Again, great conversation, lots of feedback, incorporated that feedback, new set of drafts. Damian looked at them once again, and then the most recent set of feedback that I received was just a couple of weeks ago. That was done through email, but again, some good feedback, incorporated it, and that's what you have in front of you today. There are 5 policies and 2 forms that were created. And really what they boil down to is a documented version of things that we have been doing here across our branch for a long time, with some edits and changes that we felt might be necessary to meet the needs of our employees. So that's what you have in front of you. One thing that's important to point out and to note here is that policies are fluid documents, right? These are not set in stone. They're not meant to be set in stone. They really should be reassessed and reviewed at least annually, maybe every other year once we get rolling, but they are not meant to be set in stone and then left in a drawer and left forever. So the good news is that I think through the test of time, once we implement these and we actually use them, we'll have a really solid indicator as to whether or not the forms are working, or if we've missed something or overlooked something. And the good news is that we can easily come back together as a group and make changes. So I think I will stop here just to see any questions about the process that was followed. And then I'd like to know from you how you'd like to proceed. So we can either give you all an opportunity to take some time to review the policies and send me questions, and we can talk about them again and maybe try to get approval on them at our next meeting. Or I can provide you all with some of the high-level changes that we made collaboratively as a group in each policy. I don't have all of the details with me today. That would take a year anyway with all of the changes we made, but I don't have that level of detail with me, but I can certainly review with you some of the higher level changes if you think that would be helpful. So
I think that would be helpful, Arlene, if you would go through for each policy, just give us some of the main high level changes that you made and just a brief explanation of why. I know in our conversations, the speaker and I have had with you over the last few months, it was clear that up to this point, the leave policies varied wildly depending on which department within the legislative branch you are in. And I know that was one motivating factor, is to try to have more consistency. And so I think it would be helpful just to go through quickly each of these policies, high level, try not to get too far in the weeds, but if people have questions, certainly flag them for Arlene and we can follow up after. Okay, before our next meeting. All right, great. All right, you.
I actually have one larger question.
Representative Leclerc.
Do you know how the staff accrues paid time off now?
So the staff accrues paid time off. We do use the same matrices as the state does. So they're a little bit different depending on the actual office. I believe in the Ledge Counsel office, they accrue according to what the other attorneys accrue. And then the other offices accrue according to the same matrices that the rest of the state employees use. So they don't differ all that much.
So just a quick, so for instance, like, do they have like a certain number of sick days versus vacation days versus holidays, paid holidays?
Yes, right. So we accrue sick time, we accrue annual leave, which is vacation time,
Okay,
personal time, comp time.
thank you.
Anyone else before I dive in?
Dive in.
Okay.
Thank you.
All right, so you have 5 policies and 2 forms. The first policy is parental and medical leaves of absence. And so this policy is really a derivative of what you all may be familiar with, which is the Parental and Family Leave Act here in Vermont. But this particular policy covers the things that we see most often, right? Parental leave, medical leave, short-term family leave, the leaves that people tend to take and need more often than not. So without getting into too much detail, I can tell you that one thing that we came to consensus on was the eligibility requirement for these types of leaves. The statute right now, I believe, is written as eligibility is based on someone who works over the course of a 12-month period, but at an average of 30 hours a week. And we actually changed this eligibility to be in alignment with what the other state employees are following, as well as Fmla, which is very commonly known, especially when we're hiring people coming in to the legislature who are not familiar with our local state government, are more familiar with Fmla than anyone else. And Fmla is a little bit more generous. So it allows someone to take these types of leaves if they have worked for at least 12 months, but at least 1,250 hours, which really boils down to about 24 hours a week. So it's a bit more generous and more common. So we thought that would be more here. We also broaden the definition of an immediate family member to family member. The language as it was written was a bit restrictive, and it didn't really incorporate all of our employees' needs and family units here. So we broadened it. We added things like in loco parentis language, which we also defined here in the policy. And we also added domestic partner and defined that according to our standards here in Vermont. So we broadened the definition of a family member to make it more applicable to what our employees are managing now. Under serious health condition, that definition, we changed that language a little bit. So we changed some of the language, for instance, physician to healthcare provider, because there are many, many types of healthcare providers out there now, in addition to physicians. We added 2 forms, and this is the case for all of these policies. One is a leave of absence request form, and the second is a certification healthcare provider form. And this provides us now with a process for requesting and approving leaves. So again, we have processes in place across the different offices, but this will provide us with a consistent process. So employees now can formally request a leave of absence using the request form. It can be reviewed. And then if they are looking to take a leave of absence for their own or a family member's serious health condition, their healthcare provider can complete the certification form. And that also will help us not only monitor and track these leaves, but it will also help us determine if any accommodations are needed upon someone's return or during their absences. Under
Madam Chair, may I ask a question?
Oh, sure. Senator Kitchell.
In reading this, and I'm trying to find where, if someone is going to require sick leave more than 5 days, there's a requirement that they would have to provide a medical statement. Would that be different than that more detailed form that the medical provider has for a leave of absence?
No. So if someone's going to be out for more than 5 days due to a serious health condition or a family member's serious health condition, the form would be the documentation that we would need.
And it's 5 days, that seems like kind of a short period of time.
Yeah.
Is that consistent with what's being used in the executive branch?
I would have to go back and see if it's consistent with the executive branch. Typically, it's 3 days. We broadened it to 5. Under Fmla, it's 3. We broadened it to 5 because people obviously get sick and have colds and flus and other things now. But 5 days, in my experience, is pretty standard. When somebody's out for more than a week, if they're going to be out longer than a week, they really should be requesting a leave because it really protects their job.
So I was just looking at the time frame, more than 5 days, and then they had 15 days to get the doctor's or the medical certifications. I was just thinking about those time.
The nuance.
That may be getting into more detail than I want. So
It is a little confusing, Senator Kitchell. I think, again, it really follows the guidelines of the Family Medical Leave Act more than anything else. And the 15 days is really when somebody first brings it to our attention. They have 15 days to get the forms completed. It takes a while to get that information from a physician or healthcare provider. So they have 15 days to go get that information. It rolls backwards. But if someone is typically out for longer than a week, they really should be requesting some job protection if they feel like they're going to be out longer than that.
Oh, I'm sorry, Senator Benny.
Good morning.
Good morning.
I was looking at the definition of domestic partner. One of the words that leaked out, the word enduring. Is that term associated with any other family relationship situation?
Senator Benning, where are you looking?
3 lines down under domestic partner.
that could be quite a test, enduring.
That's
There could be a dispute between the 2 partners as to whether it is or is not enduring. But I hadn't noticed that description under any other family member. I'm trying to figure out where that came from.
Well, I'd have to go back and look and see where, this is where I don't have it memorized. So let me go back and check that out. I think that we did take the language directly from somewhere. Let me check on the word.
It sounds like a word that arose in the initial stages of the term domestic partner coming into the vocabulary. And I'm just wondering why it is still necessary to be there.
I will check on that for you. Thank you for taking it out. Okay, under parental leave, which is now I'm on page 4, if you're following along. We did update this language here, again, to be more in alignment with other state practices. We changed the language for parental leave. We actually changed the entitlement from 12 weeks. We increased it to 16 weeks for 2 reasons. One is that it is more in alignment with what some other state practices are, but also it's my understanding, and it was brought to our attention on a few occasions, that some childcare facilities do not accept infants who are not 4 months old. So by requesting somebody to come back after 3 months leaves a 4-week gap there. And what would that particular parent do? So we increased the entitlement to 16 weeks. We also changed the age requirement for adoption. And we changed the language here from 16 to under 18 years of age to allow for a child who's 17. There wasn't really a provision there between 18 and 16, so we changed that language accordingly. And the other change that I just want to point out to you is actually on page 5 under short-term. Number 3. We clarified the language here just a bit. I believe it did say that somebody could take a short-term leave to accompany a parent or a spouse, parent-in-law to professional services. And there was some question as to what professional services meant. So we expanded the language and just clarified it a bit. We added that piece that says such as arranging for long-term care, hospice care, or home care services. So those are not the only options, but it's just to provide an example because we believe that that was the original intent of the language as it was written. And so those are really the major high-level changes under, this is our largest policy. Those are the major changes with this one.
Representative Colson.
Thank you, Madam Chair. I have a question about the request for extension. It's noted in the first paragraph on page 3. Should an employee be denied a request of an extension, what recourse might they have to dispute that decision?
If someone is denied, so typically what would happen if somebody is denied a leave, first of all, I would say it would be rather rare. If somebody has a true medical condition or a need to be out, chances are that leave will be approved. If it is denied, their recourse would be they can go back to their manager, they can come to Human Resources, and we can have a conversation about it. All of these types of leaves, and there will be others as well, are very personal. You know, they're case by case. It's impossible, in my opinion. So I think it would require a conversation and a thoughtful conversation, and we would have to make a determination. Sometimes there are examples where leaves of absences are requested for things like elective surgeries or surgeries that, or procedures that can be put off to other times, or people are willing to put them off to other times. Sometimes it's just a matter of having a conversation. And then of course there are times when they can't be avoided. And I would think that that would be very rare, if ever, that somebody would be told they can't take a leave for something that's medically necessary.
Thank you.
Okay, so I'm going to move on to the second policy, which is earned sick time. This one will go faster because the changes are the same. So again, we included that in loco parentis language here. We broadened the definition of family member. But looking on page 2.
Arlene, if you could just pause for a moment while we get ourselves.
Oh, I'm sorry. Sure.
No, that's okay.
So I'm on.
So there's a document that's earned sick time policy specifically.
Page 2. Yeah, sure. I'm looking at under heading number 1, general provisions, and I'm actually looking at those bullets. So we did add one bullet here, and that's the last bullet that says essentially that someone can use their earned sick time to attend a court hearing under the crime victims leave policy. We haven't reviewed that one yet, but if somebody is the victim of a crime and they need to attend a court hearing, we thought it was appropriate to allow them to use their sick time to do so. So that was the reasoning for that bullet here. The rest of this language is either in alignment with statute or processes that we've already been using.
Madam Chair.
Yes, Senator Kitchell.
On the top of page 2, Arlene, it talks about the accrual is based on employment classification. I suppose that may have double meaning for me. It might mean under the classified system, the nature, the position you're in and the duties and compensation. But I think this probably has to do with hours of employment and whether you meet the definition of employee. So classification has no relevance to classified service, but my first thought was, oh, gee, we wouldn't be treating someone who might be an administrative assistant differently than, say, an attorney. So that was, I just want to clarify what classification means in that context.
So you're correct. It is not relative to being classified. None of us are classified here at the legislature. Classification in this sense of the term really depends on, it does depend on your role. Our legislative attorneys do have a different accrual system. It also depends on your years of service. So your years of service determine your accrual. Your accrual changes depending on how long you've worked for the legislature. So we can certainly change that word to something else just so it's a little bit more clear. That's not a problem at all.
So that was one of my questions. Years of service would be one of the factors that determines accrual rates.
Sure.
All right. Thank you.
That's an easy change. Thank you. That was it for short term, for unsick time. The next for a document that's called 0003, it's entitled Pre-Eligibility. So this is the only policy of the 5 that you have that you will not find anywhere. This is something that I drafted and spoke with the department heads about because I've had experience with it in the past. And I'll try to give you a very high level summary, but basically this would be put into place for someone who is new, who has not yet met the eligibility requirements for taking a job protected leave, which is 12 months. So someone who's new right now, I'll use myself as an example. If I had an injury or an illness or someone else who's new, you would have to wait until you were employed for 12 months if something happened to you in order to have a job protected leave. So in my experience, I've had other situations in other organizations where we've used similar policies to allow for a 30-day protected leave for a new employee, only for their own serious health condition, their own injury or illness, not for a family member, and it would have to be taken in consecutive days. So it would be a 30-day protected leave. They could use their accrued time after they've hit their 6-month mark. Although here at the legislature, we do have a bank of time that is afforded to us for sick time when we begin. We've got a week of time. So that could be certainly used. And if they were here longer than 6 months, they could use any accrued time, but it does afford them 30 days of protected leave. It also has another benefit, and that is in situations where you may have an employee who's new, who starts, and something happens, and in an unfortunate way, they're not able to return for many months. And this provides us also with some protection that allows us to make some decisions and some determinations if we felt like that absence vacancy was going on too long.
Arlene, I just want to personally thank you for bringing this to light. I know certainly many of us outside of our jobs in the legislature have come up against this either for ourselves or for other people working with us or for us. They're caught in between that timeline, and we can't control when we get sick. We can't control when we have a horrible accident, and I really appreciate you shining a light on this.
Welcome. Thank you. The next one is the 4th policy. It's the easiest one. It's jury duty. This was created as a bonus, really, because what happened was while I was drafting these policies, I did have a few people who were called for jury duty, and there was confusion about how do we pay the person if they, can they use their own accrued time, or do they use the pay that's afforded to them by the court? So while we were dealing with those situations, I thought that I would just draft the policy. It doesn't divert from anything that we've always done, or it doesn't divert from any statute or policy at all. It really is just documented so that it's easier for us and we can reference it. I don't think it's often that we have employees who are called to jury duty, and we certainly want to support them in their civic duty, but we also want to be clear as to how they should be paid if it happens. So no changes with that one.
Just completed my first jury trial since March 2020. Just forewarned state employees, they're coming back on the hook again. Good time.
It is a good time. Yeah. In Massachusetts, you get called a lot, and I was called a lot. The last policy, and then we just have the two forms, which will be quick, is policy number 5, which is crime victims. Just one change to this. I should point out that this actually falls under our parental and Family Leave Act, but we called it out separately for ease of use. When I first drafted these policies, they were all in one big document, and it was really, really hard to get through. So called it out separately. We did want employees to know that this is that is afforded to them. I'm not sure that it's widely known here at the legislature, but if someone is a victim of a crime, these are the things that they are afforded, and they are afforded time out of work for different court proceedings. But we did add number 5 at the bottom of page 1, because again, we thought it was appropriate. And that says that you could use this leave to attend a meeting with a minor family member's attorney when the minor family member is a victim. We thought that that was appropriate because, of course, a minor family member would need some assistance in a meeting such as that. So we added that here and thought that that was appropriate.
So Arlene, as a criminal defense attorney,
What's-
there is a presumption built into this that the individual is a victim. Our court system is based upon a presumption of innocence. There is the policy here for someone who is a complaining witness. Is there a policy for someone who is charged going through the same process?
Currently, we have not crafted one currently. This did come up in our conversations. There was a conversation about, if the family member was accused of the crime. So we did have that conversation multiple times. And at this juncture, this was the language that we decided that we would add, but certainly willing to hear what your thoughts are if you think it should be different or otherwise.
Well, I guess I'm troubled that the assumption is built in for an employee who is a complaining witness. Actually label them as victim of crime before there is a trial. It's troubling to me that if you're going to extend that to someone in that position, that you're not also extending it to someone who is accused of the crime. And perhaps they need it just as much, if not more, than the person who is a complaining witness. They have to meet with their attorneys. They have to attend court appearances. They have to go through a trial to determine whether they are guilty or not. I guess I get a little uncomfortable when we pre-label someone as a victim. So I've got two issues there. One is the label that's being attached. Second is that you are not affording it to the other side of that equation.
No, thank you. And I believe, although I'd have to reference my legal counterparts in the, or probably like,
She's like,
I wouldn't look at
phone a friend.
yeah, but I could phone a friend. I believe that the crimes, that this language is in statute. Does anyone?
Secretary Bloomer, feel free to come up.
I raised the same issue, Senator, and what I think the decision was that this is a statute that exists in Vermont. And so rather than try to wordsmith the inclusion you're talking about, given that it wasn't in the existing statute, that we would stick with what is in the law. Whether that's the right decision or not, it was the way of moving forward. But I will tell you, I was involved with your discussion because I raised the idea that someone who is accused should be able to use the child. But we could not figure out within the time frame, or at least the conversations I was involved with, figure out within the time frame how to draft that without some guidance from the legislature and doing something different than state law. But I think that's why the decision, at least the conversations I was in, ended up where it was.
There's really nothing I can do about it in this setting, but I guess I wish that there would be some further conversation about that, because it just seems terribly unjust to me to give someone who is a complaining witness a presumption that they are the victim of a crime. They may very well be. I'm not trying to dismiss that, but our legal system is set up in such a way that nobody is officially a victim unless and until someone has been proven guilty beyond a reasonable doubt. And those policies ought to match for both sides of that equation in a criminal case. That's my humble opinion.
And so just as a reminder, we are just looking over these draft policies. So there is absolutely time for us to have this conversation, and want to encourage all interested parties to have that conversation and bring forward ideas to both Arlene and the committee as a whole. So
Yeah.
you have what you need, Arlene, in terms of responses from both of them to move forward. And is there anyone else that would like to speak on this particular issue? Thank you, Senator Benny.
Yep, thank you. Right, so I did make a note of that, and it did come up before. The last two documents are just forms. They are attachment A and attachment B. One of them is a leave of absence request form, and the other one is certification of healthcare provider. A few things about these that you should know is that they do currently align with other state forms. They also are aligned with Fmla, so I didn't make them up. We did change some of the language to make them more aligned with our policies that you have in front of you. But essentially, both of these forms, as I was saying earlier, they provide us with a process for requesting and thereby tracking and monitoring leaves. It does allow us to get a formal healthcare certification from a healthcare provider when it's necessary or needed. It will allow us to track dates more efficiently, more consistently across the offices. And it will also allow us to have clarification and written clarification as to whether or not a reasonable accommodation is requested or needed, which I think is really important. So we created these forms accordingly, and they will be part of the process once everything is approved.
Yes, Representative Leclerc.
Is there any definition of what's considered a healthcare provider? In other words, I mean, I know we started with the physician. I want to compliment you that you went to healthcare provider, but you know, you have a physician over here, but would say like an RN, a physical therapist, a chiropractor.
So we did have this conversation again, because we did want to replace just the word physician. But I think I will phone a friend if anyone, Jennifer, has an answer. I'm not sure if you do or not, but
I can. So Jennifer Garvey, Licensed Counsel. I think this is a question that always comes up as far as what you don't have a statutory just one definition of a healthcare provider. But I think in general, with these the term you're meeting somebody for whom making this kind of determination also so a physical therapist, I don't necessarily think would be able to make for example, a medical determination of cognitive ability. So if it's not within their scope of practice, it wouldn't.
Thank you.
Representative Ansel.
Question about the payment of insurance premiums. And is that intended?
If you could, Representative Ansel, just to speak up a little bit.
Oh, I'm sorry.
Yeah.
The bullet on payment of insurance premiums, it says that the employee on unpaid leave of absence is responsible to pay insurance premiums. Does that mean that they're paying their employee share while they're gone? It doesn't mean that they're paying the state share.
Correct.
Is that
Yes,
right?
yes. And that is documented elsewhere in the policy. They're responsible for their own fee contribution.
Yeah, thank you.
Excellent clarification. Other questions or concerns for Arlene? Arlene, I know I speak for the speaker as well when I say thank you for your diligence and thoroughness and professionalism. I know we have given you so much work to do in the short amount of time that you've been here and appreciate it so much. So going forward, we'll be taking more input from everyone on this committee about the drafts that we've seen today, and we'll be looking to, at a future meeting, finalize these policies. So,
Great.
Thank you.
Thank you
Thank
all
you so much.
for your input.
Thank you.
at this time, I'm going to ask fiscal analyst Dan Dickerson to join us to go over the FY22 budget adjustment and the FY23 budget for the legislature.
Morning, everyone.
Good morning.
For the record, Dan Dickerson with the Joint Fiscal Office. I guess before I dive into my documents, I want to just take some time to give a little bit of history and a little bit of context, which I think will be helpful for some of you that may not like swim in budget parlance, day in and day out. So going back to 2019, Act 144 passed, which created the Joint Legislative Management Committee and also sort of restructured the legislative branch. And so, from there, we now have several new offices: the Office of Human Resources, the Office of Legislative Operations, the Office of Legislative Information Technology, and then some of the existing offices changed a little bit with that. And so that actually created at least one new, what I call appropriation unit, and that is, an entity that's receiving an appropriation through either the big bill, which is the budget, or budget adjustment. And that was the IT office. So with that said, we now have 5 entities that receive appropriations, which would be the legislature, and a part of that appropriation is, of course, the legislative salaries and expenses, but also the Office of Human Resources, the Office of Legislative Operations, the Clerk of the House, the Secretary of the Senate, and the leadership assistants that you have. And then there's the Joint Fiscal Office, of course, Legislative Council, Legislative IT, and Sergeant. 5 different appropriations, and those are the proposals that I'll present to you today. On top of that, here, there's of course a pandemic that happened back in 2020, and so prior to the pandemic, we had proposed budgets for then fiscal year FY21 at specific appropriations, and subsequent to that, we're asked by the executive branch, all offices in state government, to lower those requests just because of the economic uncertainty at the time. So we did that. So FY21 budgets were lower than we'd originally requested. We got some of that funding back in actually we got most of that funding back in FY22. But we're still sort of building back to where we were, and a little bit of that is brought back in FY23. But as far as sort of the terminology, like I said, just because I don't know if everybody swims in budgets every day. We
Assume that some of us do not. Thank you, Dan.
we receive our spending authority through appropriations that happen in the big bill that usually passes at the end of every session, and then at the beginning of the next session, there's usually a budget adjustment bill, and that's where departments can say, well, we need a little bit more funding for this or for this, and they modify the budgets that way. And then at the end of a fiscal year, if an office hasn't spent all of that spending authority, that goes forward as what's called carry forward. And you can continue, depending on what's in law, you might have to hold on to that and finance, like if you're an executive branch agency, finance and management might have to work with you to figure out whether you can spend that or give it back. For us, we typically get to carry our carry forward into future years to use for one-time spending initiatives. The other option is give it back in the form of a reversion. And for us, the reason we typically get funding back as a reversion would be to, I guess, to offset some of our budget growth. So let's say our budgets are growing by, $500,000. We can give back $500,000 of reversion to basically, net us out to zero for 1 year. Obviously that, that growth continues, but, so that's a little bit of background. As far as, further impacts of the pandemic, within the legislature's budget, which is the legislators, we've accrued fairly large carry forward balances, and that's because most of you haven't been traveling for the past almost 2 years now. So the funding that we would have budgeted for travel expenses hasn't been spent, and we've been accruing. And let's see. And then in Act 74, which is the big bill that passed this past session, several new positions were created across the legislative branch, for which we're very much appreciative. It's allowed us to serve you better, and I think it's allowed us to sort of breathe a little bit. We've all been pretty busy. And those positions are all fully funded between the budget adjustment request that we have and the budget proposal we have for FY23. I will say, in my time working on budgets for the legislature, I've not had to create a budget adjustment request, so this is a little bit new for me. But with that said, I will jump into my materials. I'm going to work from this spreadsheet primarily. For those of you that don't have, seeing two of you that don't have computers, you might want the larger copy, unless you're fine with the 8.5 by 11. So going into our budget adjustment request, there are 3 items that we're seeking additional funding to pay for. 2 of those within the Joint Fiscal Office, and I'll touch on those first. The first item is we're asking for $125,000 of funding to pay for our IT project review consultant. And just to give some background on that, we have employed a consultant to look at these executive branch IT, executive and judiciary branch IT projects since 2015. It was previously an individual named Dan Smith. Some of you have probably seen him in committee testimony. He retired this year. We've since employed a new person that is on a 1-year contract. We're going to see how it works out. But the reason I'm asking for funding through the BAA is this has been sort of an ongoing work within our office, us coordinating with this individual. I think the legislature has been interested in continuing the effort. In Act 74, we were directed to fund this work through a transfer of legislative carry forward, from the legislative budget to JFO. I felt like just getting the funding into our operating budget was a more suitable way going forward, at least for the next few years, and then we can reassess. I'll just say all of what we're asking for in the BAA, we plan to pay for through a reversion. So we're asking for, across the 3 requests, we're asking for $295,000. There's $295,000 in carry forward in the legislative budget. We plan to offer back as a reversion to net that out to 0. The other item within the Joint Fiscal Office is that a limited service position. We asked for a limited service position to the Joint Fiscal Committee, and the committee authorized the creation of that position, primarily to be focused on work surrounding the American Recovery Plan Act, the ARPA funding. As some of you may remember, in Act 74, the big bill, you allocated a lot of money towards, I think, 5 big sort of funding tranches, I guess, clean water, economic development, broadband, housing, I think there was one other, maybe IT. And we want to be able to sort of look at those issues, provide staff support and analysis and research for those items over the next few years as you continue to allocate what's left of the ARPA funding, but then also sort of monitor what's happening with the money that's already been allocated. So we felt that having this new position would allow us to do that over the next few years. I will say that I've sought the possibility of funding the position with ARPA funding, but I haven't gotten to a point where I feel comfortable asking for that, and that's just because of the Treasury guidance. So for now, I'm asking for general fund to pay for the position, but that could change. Hopefully it will change, but we're not there yet. And then the final item is within the legislative budget, and that is $105,000 in funding to pay for the HR assistant position that was created in Act 74. The budget language for Act 74 authorized the position, but didn't actually provide funding in the legislative budget, and I felt like it was appropriate to have it there. So those are the 3 budget adjustment request items. Before I go on, I'll ask if there are any questions. Great. So moving on to FY23, on this sheet, I'm going to go through items 1B through 7B. And I will say that the first 3 lines that I have here, Pay Act, benefits increase, internal service, those are all budget pressures that we can't control in really any way. The Pay Act that started in July, it was a 4.15% increase for all legislative staff and for all legislators. That's $388,000 of additional cost in FY23 that we have to budget for. These benefits increases, there are 2 parts to this. In July, the state share for those participating in the defined benefit plan increased from 21.4% to 25.5%. So we're building that in going forward. And then starting on January 1st of 2022, health premiums, both on the state side or the employer and the employee side, are going up 7%. And then in January 1 of 2023, they're going up another 7%. And so that averages out to 10.7% in FY23, which sort of goes over both those periods. So that's about $250,000 of additional costs. And then this ISF, these are internal service fund charges. These expenses get allocated to all state offices for use of basically shared state infrastructure, whether it's the buildings that we occupy or the vision accounting system that you probably do your expense reports on, and we pay bills through, workers' compensation and other insurances. When the executive branch budget guidance came out, we were instructed to assume that those would go up 3%. The likelihood, those are most likely to go up more than that. But at this time, we're carrying a 3% increase. And there'll be some more context to that in the motion that I have in my memo, but I'll leave it at that for the time being. 4B staff changes. These are also additional pressures that are really out of our hands. And it's mostly attributable to the fact that over the past year, we've had some turnover within the legislative branch. So people leaving are on, a certain benefit package, people coming in are on a different benefit package. And in most cases, that benefit package has been more expensive. And a lot of it's driven by people going out who are on the defined contribution plan, which is a much lower cost on the state share side. And then the people coming in are on the defined benefit plan. And then some people just have higher health premiums. The new staff piece, this is where we get into slightly more discretionary budget pressures. There are a few pieces to this, one being the limited service position that was created in the Joint Fiscal Office. We're we're asking for 65,000 in FY '22 to fund the position basically from today until the end of the year. And then the remainder of the funding that is needed is built in FY '23. So full year is about 105,000. So it's an additional 40,000 that we're. And then a few other items were within the Joint Fiscal Office. We also have a temp individual that's actually doing a great deal of work for us. And we're hoping to convert that position to a permanent, so that the person can at least have access to the state benefits package. The individual would still be part-time, but there is some funding for that. And then within the Office of Legislative Operations, discussions with Mike Ferrant, he indicated that committee assistants are putting a lot more hours in the summer now, just due to, there are a lot of study committees happening. So he wanted a little bit of funding just to have some breathing room to bring in more assistance as needed. And then the 6B, all those changes, a lot of this growth, about half of it is on the IT side, just an increased costs of IT contracts and some of the services that, especially the Microsoft platform. And then the rest of it is pretty minor, just continuing to boost up a little bit of the operating capacity that we gave back in FY '21 when we had to reduce the budgets for the pandemic. So printing and copying that historically happens in the State House, that hasn't really happened. We're getting those budgets back up, and then some of the legislative travel. So in total, the budget growth in FY '23 is about 982,000. I've put together a package of reversions from various offices totaling about 250,000. So the net budget growth is 732,000 in FY '23. And then jumping to the memo, if you go to the very end, I have two proposed motions for you. The one pertains to budget adjustment, and the other is for the budget. The one for the budget is a little bit wordier, just because going back to the internal service cost piece, I think those are probably going to be higher than what we've budgeted. So I wanted to give us some flexibility to change our numbers if needed, and the mechanism would be the chair and vice chair of Jlmc would review the numbers and make a determination, whether Jlmc needs to convene again and take another vote on the budgets. But I anticipate that would be the only potential change, and it's one of those things that we can't really control. That's all I have.
Thank you, Dan. Representative Leclerc.
Morning, Dan.
Morning.
I just have a couple clarifying questions. One, backing up to the Pay Act and benefit changes. The 7% as of January 1st, 2022, and then January 1st, 2023. How does that average out to 10.7%?
It's a little odd. I guess you take you're taking the current premiums, you're adding 7% in January 1st, and then the other 7%. And I guess if you take the sort of median of those, you would think it would be 10.5% because it's 2 years, but it goes up a little bit more than that. I'm having a hard time explaining it, but
Somebody wants that's the number that we got from finance and management for the FY '23 estimated. So 7% was probably a rounded number. It's probably 7 point some. That's the reason we're carrying the 7%. That came from the computer finance and management. It's the way the fiscal year, the calendar year overlap that create the
Okay.
the fact that it's 7% in 1 year.
That makes sense. Okay.
By the end of by our FY '23, it'll be.
So it's kind of a prorated number. Okay. All right. And then the last question, I picked up that there is a temp position that you're looking to convert into full-time benefits. Could you, what's that again?
It's a part-time position within the Joint Fiscal Office that is currently temp. We do want to convert it to permanent. We have a vacant position that we think that person can fit into. So I don't think we need to ask for a new position.
So it's a matter of,
We're just looking for the funding to be able to offer the benefit.
okay, so you already have an existing vacancy that you're just gonna, okay, got it. Thank you.
And I apologize for my fumble answer on that.
Excellent.
That was actually one thing that we just caught wind of, Thursday of last week, and I sort of rushed to incorporate those.
Oh, Dan,
changes.
healthcare gives us all a headache. It's really okay. Other questions, clarifications needed from Dan? Yes, Senator Kitchell.
Well, I'd just like to tell the committee that the appropriations chairs and the finance and ways and means committee chairs did review this in detail and went over the reasons why. Obviously, there's a lot of movement because of we had some lower costs because of just the COVID related, but also the fact that we have put a lot of resources into supporting the administration of ARPA and these federal dollars. And because of the federal rules, as Dan is pointing out, there are limitations on what the legislative branch can secure to support the work. But the volume of work associated with those millions of dollars and the committees saying, what will be the impact of this policy and so forth has really had tremendous budgetary implications. And this is when we look at the number of positions that we have authorized to support this, the other branches of government, or even with community-based organizations, we felt that this was a workload that had been unaddressed. And so I just wanted to provide that back in addition to Dan's testimony today. And with that, I would maybe start with the first motion.
Yes, please.
To support the fiscal year 2022 legislative branch budget adjustment appropriations as presented to this committee on November 1st, 2020.
Senator Kitchell has moved to support the proposed fiscal year 2022 legislative branch budget adjustment appropriations as presented. Second, Representative Ansel. Any further discussion? Now call the roll. Representative Krinsky.
Yes.
Senator Kitchell.
Yes.
Senator Benning.
Yes.
Senator Mazza.
Yes.
Representative Ansel. Representative Colston.
Yes.
Representative Leclerc.
Yes.
And chair votes in the affirmative. Thank you. That motion passes. Senator Kitchell, you want to
Yes,
continue?
I'll do the second motion as well, because this obviously is really important. And
Yes.
To support the proposed fiscal year 23 legislative branch appropriations as presented. I don't need to go joint legislative management committee on November 1st. And require the chair and vice chair being notified of any substantial changes prior to the executive branch recommendations to determine what whether formal review of this committee is necessary.
Senator Kitchell has moved to support the proposed fiscal year 2023 legislative branch appropriations as presented to the JLMC and require that the chair and vice chair will be notified of any substantial changes prior to the executive branch budget recommendation to determine whether formal review by this committee is necessary. Looking for a second, Representative Ansel. Any further discussion? Now call the roll. Representative Krinsky. Yes. Senator Kitchell.
Yes.
Senator Benning.
Yes.
Senator Mazza.
Yes.
Representative Ansel. Representative Colston.
Yes.
Representative Leclerc.
Yes.
And the chair votes in the affirmative, and the motion has passed. Thank you so much, Dan. Really appreciate it.
Thank you all for your time.
So the last item on our agenda is to hear about the Director-in-Chief Counsel hiring process. And before I look for a motion to go into executive committee, I will just say there has been a subgroup of this committee working to hire, to do interviews to hire the director and chief counsel position for legislative counsel after the departure of Luke Martland. The committee has completed those interviews in the process, and we are ready to make a recommendation to the committee. So if there is any non-specific questions related to that, if there's questions about process, before I ask for a motion to move into executive session.
I move that we move into executive session.
Thank you, Senator Kitchell. Do I have a second? Representative Ansel. All those in favor say aye.
Aye.